Welcome to the broadcast. My name is Marty Schenkman, and we have a really important topic that just doesn't get addressed enough, and that's planning for single, unmarried clients. And we have a great panel. I'm very pleased to say that Jonathan Blotmacher will join me and speak about estate planning and a host of other issues. Bob Keebler, well-known CPA, brilliant guy, is going to talk about some of the income tax issues and may pepper in some other comments. And to round out the discussion, we have Rebecca Provder, who's a family or matrimonial attorney, who's going to offer some comments on planning for single individuals so that we can really give you a holistic, broad perspective on this very important topic. I'm just self-conscious, so I just had some dental work done. My face is still numb. Forgive me if I look a little funny or drool. A couple of quick comments to get going. The PowerPoint is available for download on the web console during the program, so if you haven't downloaded it yet, just click on the handout icon and click download. Recording of this program and all the other programs we do will appear within less than a week on schenkmanlaw.com, along with the handout materials. Our two sponsors, who will introduce themselves in a few minutes, Peak Trust Company and Interactive Legal, also posted to their slides as well. If you want to get CLE for these, the last slide tells you where you can go and rewatch any of our programs. They have them all and get CLE credit. We do not give CLE or CPE or any other type of credit, but we do issue a certificate of attendance for those of you who can self-report. Please note that we cannot modify whatever's on those certificates. They're generated automatically by the system. Finally, if you have any questions, kindly email the panelists. All our emails are on the last slide, and we'll get back to you. That's a better way to get an answer than posting to the web console a question during the program. So let me turn it over so we get started first to Vanessa Kanega from Interactive Legal.
Thanks, Marty. Thank you and welcome everybody to another great practical webinar. We appreciate Marty for organizing this, and Interactive Legal is glad to be a sponsor. And it's nice to see my friend and former colleague Rebecca Provder on here as well. You'll all get some great practical advice from her. We're just pleased to sponsor this webinar along with all the series of the Schenkman webinars. And as Marty said, you can find them, the back catalog, as it were, on our website. If you'd like more information on our automated drafting programs for estate planning and elder law attorneys or our other resources, please feel free to reach out to us at the email on your screen or visit our website at interactivelegal.com. Thanks very much.
Thank you, Vanessa. And Nicole will give a word or two about our other sponsor, Peak Trust.
Yes, thank you. Welcome, everyone, and thank you for attending today's webinar. My name is Nicole King, and I'm a trust officer here at Peak Trust Company. And we are pleased and honored to be able to sponsor today's presentation. Just a little bit about Peak. We offer a full spectrum of trustee services, servicing individuals, families, and their trusted advisors. We offer flexible and customized administrative services for all types of trusts. So I invite you to visit our newly designed website at peaktrust.com. And if you should have any questions, please feel free to reach out to me. Enjoy the webinar. Back to you.
So one of the things to say about Peak and about institutional trust companies in general, and we're going to talk about this at several points during the program, when you're dealing with a single client who not only doesn't have a spouse, but doesn't have children, they don't have the usual cast of characters that many clients will name in various fiduciary capacities. And one of the very important ways to protect a single client that doesn't have the family safety net that some clients do, and frankly, many clients even in other circumstances don't, is to use an institutional trust company. So thank you, Nicole, for your comments. So to get started, let me just take a second. And there's nothing magical about the statistics, but I'm going to just talk to you a minute about some of these statistics because I think they're kind of eye-opening in that so often estate planning conferences and programs presume that the people involved are married. The examples and hypotheticals that are so often used are still oddly based on the Cleaver family, when that's a very small percentage of the actual family units in our country. And to those of you on the panel, feel free to jump in and interrupt at any point while I'm chatting about some of these stats. So the first statistic is astounding. More than half of the adult population is single. That's almost 25 million people. So we as a profession, and when I say as a profession, I mean all the allied professions, attorney, accountant, CPA, insurance, financial planning, we need to give more attention to single individuals. In 2020, approximately 36 million people were living in single person households, very significant. The remaining stats are from the website that I listed. Nearly 40% of the unmarried population, age 18 and over, were formerly married. 60%, over 60% have always been single. So it's not only death or divorce that results in people being single. There's a very substantial number of people in our country that have chosen to be single or are single and have always been single. Almost
By the way,
70%.
Marty, let me
Sure.
interrupt here for a second. That doesn't mean that they will be descendantless. As we're going to mention a little bit later, a majority of women who are under the age of 30 in the United States, if they have not gone to college, have at least one child out of marriage. So just because you've never married does not necessarily mean you won't have a descendant, but the number of people who do not have descendants, just like the number of people who are not married, has increased dramatically over the past couple of generations.
Good point. And we're not going to get into much about assistive reproductive technology, but medical technology has progressed where somebody may make a conscious decision to be single and a conscious decision to have a child. And those options have expanded dramatically. Almost 40% of all births are to unmarried women. About 2/5 of children are expected to live in a cohabiting household at some point. So really, it's a very different dynamic than the Cleaver family that for some odd reason remains this sort of paradigm or model for many discussions. Just a quick comment on attorney ethics. Be mindful of conflicts of interest. Who are you representing? If there's two unmarried people that are cohabiting, who are you representing? Rebecca, do you want to comment at all on some of the representation issues?
Sure. So in particularly with respect to where you see it more, where a lot of times people have gone in for their estate planning as a couple, and then they find themselves separating, that oftentimes that is an issue. Or other times where you see it where you've done a prenuptial agreement perhaps for one person, and then they want their fiance also to come and use the same practitioner, then you run into some issues. And so you do see this quite commonly. Then you also have the things where you see along the way, if there's a child from another marriage where their partner may not know about, where there could be different completing interests in terms of if it's a couple who isn't married, what they'd like to leave to the other. So it's important that these issues be addressed head on in the beginning of the representation so you don't create problems down the road.
Let me add that
Sure.
this is because, as Marty said, we no longer have the Cleaver family as the model where it's a married couple with kids only from that union and they stay together at least until one of them dies. But you've got to warn the couple, no matter whenever you're representing two people, even in a long-term marriage, that a conflict possibly could arise. And that will make it impossible for you to continue to represent both of them. In fact, it may be that you'll have to stop representing either of them. You just won't be able to do it at all. That's important to get up front because people get extremely emotional when their relationship, whether they're married or not, begins to break down. And they're going to want you to take sides. So you need to warn them. And I always used to put this in writing, whether it was a couple just living together, and that was for a long time. If you had a homosexual relationship, two women, two men, they couldn't legally get married, but you'd still have the potential of conflicts arising. So make sure you get it in writing, even for a long-term married couple, that a conflict might arise and you may have to resign from representing both of them. That's important for your own sake and also to advise them that that could happen. Keep in mind, and Rebecca, I don't know what experience you have, but I've known a lot of couples who have been married over 30 years who get divorced. It's these gray divorces, as they're called, are much more common today than they were in prior generations.
We're going to talk about that also again at the end, where we cover a segment on older single individuals, because gray or silver divorce is a major factor. Rebecca?
And I see that a lot in my practice. I've had as much as people have been married over 50 years of marriage. We appeared before the judge and he said, you know what, after 50 years, you should just be a statute of limitations. You're stuck together. But in practice, that doesn't happen, obviously. And so it really is for a variety of different reasons where I see it much more commonly in the practice, 30, 40 plus years. So we could address that further later on, but I have a lot of experience in that area.
So let's change gears a little, because again, we're trying to give you a holistic overview of practical planning for single clients. And let's turn it over to Bob Keebler, who will give us some insights on some of the income tax considerations for single clients. Bob?
Well, thank you, Marty, and it's an honor to be here with everyone. From an income tax standpoint, one of the key differences is with IRAs and qualified plans, we do have to address those much differently. The first thing is the beneficiary forms become incredibly important, because we want that money to land in the right place. Now, very important if someone's divorced to review their beneficiary forms. And IRAs and qualified plans can be vastly different. The case law on the federal side, all the way up to the U.S. Supreme Court, is if H and W get divorced, and H is always the guy, he's too lazy to change his beneficiary form, and then he dies, it's going to his former wife. Now, the law in most states, if that were an IRA, the law would step in and say, no, it doesn't go to the wife post-divorce, it goes to the next beneficiary. But from the federal side, Kennedy versus DuPont, several other cases, you're going to be in a position where it's going to pass to the former spouse. So be very careful with this. So,
well, Bob, let me interrupt here 1 second. One of the things you can do is when someone says, I'm going to designate my wife or my husband as the beneficiary, you can add the words, if we are married and living together as husband and wife at the time of my death. Now, that may be something hard to swallow. Unfortunately, in my practice, most of my clients did not come in and ask about advice in designated beneficiary of a qualified plan or an IRA. They just did it on their own, either at the bank or at work or something. And one of the things you can do, and this is for a married couple, not just single people, say, I want to talk to you about the designation of the beneficiaries of your retirement plans. And then you can put in, even though it's very, very remote, let's put in, if we are married and living together at the time of my death. That would eliminate that problem, because as Bob says, it's a real one. Your state will provide that if you have a will and you've named your spouse and then you get divorced, your spouse is out. He or she is treated as though they predeceased you. But that's not the case for many other kinds of designations, including life insurance and qualified plans. All of those really need the supervision of an attorney.
right, and I would encourage the financial planners and CPAs, if a client goes through a divorce, get them back to the lawyer, to an estate planning lawyer friend of yours, just to make sure everything's exactly where they want it to be post-divorce. Now, remember, from an income tax perspective, QCDs are going to be very efficient if somebody wants to give to charity. You can do $100,000, it doesn't matter whether you're married or single. Naming a charity is going to be very tax efficient for your IRA or qualified plan. So if, let's just say, a widow comes in to see you, she has $1 million in her IRA, she's 82 years old, and she wants to leave it all to her favorite charity, do that coordinate that with counsel, but do that through a beneficiary form. Do not try to weave it through a trust. Just leave the IRA right to charity. Obviously, no rollover. Yeah, so you really have to think through a plan. Minimizing the income tax. Here's what we've been doing for married and unmarried couples since Secure passed. More life insurance. Take money out of the IRA or qualified plan to buy life insurance, A. B, do charitable remainder trusts whenever possible, when somebody has a charitable goal. C, Roth conversions, especially in a state where there's a state estate tax, are going to be much better than trying to wrestle with the 691C deduction, which is notoriously inefficient. And then we also want to look at, should we name a trust in a state where there's going to be no income tax? So let's say that you're in a state that will allow you to do this. You might name Peak Trust in either Nevada or Alaska as the beneficiary. So I'm a Minnesota resident. I die. My IRA goes to Peak Trust in Nevada. Minnesota, under the Felding case, doesn't have the right to tax that, okay? Very, very clear on this. So put that in the back of your mind. Does that work for a $500,000 IRA? No. Does it work for a $4 or $5 million IRA? You betcha. That's going to work very, very efficiently. Let's go up to the next slide, please. Now, the one thing that you want to check, so if you're the estate planning lawyer, someone comes in to see you in what we'll call a premortem context, and take a look at their tax return, and do they have capital losses, operating losses, passive activity losses, or charitable carryforwards that are going to die with them? Because if they do, you may want to take some proactive steps to use up those losses before they pass away. Now, with a married couple, the difference is if I die in July, my wife, with the right advice, has August, September, October, November, and December. She has 5 months to figure out how to use my losses before she dies. She can still use those on her final 1040. Where if a single person dies, they just die with that person at that nanosecond in time. Now, one of the best things when you have net operating losses or a loss for the year or a charitable carry forward is to do Roth conversions. Another idea which may become very important is, depending what happens with the Van Hollen bill, if there is no step up in basis at death, I might, right before I die, I might sell stuff to burn up some capital loss carry forwards if they're going to die with me. So these are very important things. I think for lawyers, either bring in the client's CPA and say, is there any of this going on? Or learn, and it's not a difficult thing, learn how to read these tax returns to determine if there are any types of losses like this. The problem is the federal tax return, the presentation of it has changed within the last 60 months. So sometimes even when I go looking for something, I have to step back and say, okay, where would that be in this new format? So again, think through this and make sure, especially loss carry forwards, can we burn those up before someone passes away? I had a lady where we had $1,869,000 carry forward. He did a big Roth conversion, hardly paid any tax on it. And now that Roth is growing 3 or 4 times since we did that conversion. All the growth is tax-free. One more slide, please. Now, remember, when somebody dies with an IRA, we're up against the 10-year rule. With annuities, before I die, have my financial advisors reach out to the annuity company and find out what options we're going to have and how that's going to play out. Now, this can be especially important when you want to leave that annuity to a trust, because in all likelihood, within 5 years, you're going to have to take the money out of the annuity and pay the income tax, which raises the question of whether you're better to leave that to a CRT for that child or grandchild. Also, on the S Corp side, make sure you have a plan to preserve S Corporation status. And because you're going to have a couple of years to do this, but you want to make sure you know where that S Corp's going to end up and whether you're going to be able to make an SBIT or a QSST election. This is just a small checklist, but it's to get us thinking of things that might help single people when they pass away. Marty, back to you.
Yeah, before we go on to the next topic, Bob and I are working on a case for a single elderly individual that I think just very quickly can illustrate some of the way income tax planning and estate tax planning will potentially forever change if some of the pending proposals are enacted. So this gentleman has, let's say, about a $10 million estate. Virtually all of it is highly appreciated securities that he's held forever. If that gentleman waited until he dies, and then on death there's a deemed realization event, you not only have $10 million of capital gains, but those capital gains, because income could be, and we don't know how it's going to apply yet, but the Biden proposal in his budget is that when you have over $1 million of adjusted gross income, you have capital gains taxed at ordinary rates. So roughly about a 40% rate versus a 20% rate, double the tax rate. So one of the things that we've approached this individual and his family with is perhaps what you should do is intentionally sell appreciated stock today, trigger gain just under the $1 million threshold. So those gains are taxed at 20%. He's in his mid 90s. When he dies, it could all be taxed at 40%. So you could have a 20% spread by recognizing some of the gain now and removing the tax that's paid on that from the estate as well. Very different approach to planning than what we've ever done in our lives. So the next question is to talk a little bit about status. So somebody can be single, not have any significant other or partner or relationship. And what we have to focus on with planning for somebody like that is building the right safety net to protect them in the event of a disability or other problem. Jonathan, you want to talk, and Rebecca can certainly chime in about common law marriage as another status for single people?
No, I'm surprised it's not better known by professionals in the estate planning field. But there are still 8 states in the United States, we have them listed down, including the second largest state in the nation, Texas, that recognize common law marriages. This is where you haven't gone through a formal ceremony and you haven't gotten a marriage license, but the couple can basically admit that they are married. In fact, there are presumptions in many states that if you've lived together as a couple, you will be deemed to be married. Now, that can have good points and bad points, as we're going to discuss. But if you're in one of those states, you may have a common law marriage if you've been living with someone for quite a while. And one of the interesting things now is that previously it was only where it was a man and a woman. Today, because the United States does recognize and must recognize homosexual marriages, whether they're between 2 women or 2 men, you may have it happen more often in some of these states, such as South Carolina or Colorado. So keep that in mind. And in fact, the couple can say to each other, I'm your spouse and you're my spouse. And if they do that in one of the states, they will be considered legally married under the common law. And by the way, they don't have to live there for it to happen. So if you have a couple, say, in New York, and they go to Montana, and they've been living together for a long time, and while they're in Montana, they basically use the words, I'm your spouse and you're my spouse, they may in fact be married. That can be very good from a tax perspective. It also can be bad. But don't be shocked if they take that position. Of course, it's obviously better to make it clear if you want to be married, go through a formal ceremony. But keep in mind that you can be deemed married if you're in one of these common law states, even if you don't reside there, by going to one of those states and basically taking the vows to each other. Also keep in mind that previously many more states had common law marriages. So Florida had it up until just a few years ago. New York had it until 1967. And every once in a while, someone will say, gee, we were together in Florida before the magic date there. I forget what it was, 1990 or something. And they say, yeah, we're married. Or one of them claims if there's a split up that they were married, and that spouse will be entitled to rights such as to marital property or even to alimony. So keep in mind, and you need to warn your single clients if they're living with someone of that. And in fact, Rebecca, do you ever get asked to do kind of a living together agreement between spouses?
Yes, that with increasing frequency. I mean, the numbers of couples who have been, who now live together and are unmarried has grown very significantly in the past 2 decades. It was about 6 million people 20 years ago, and now that number's up to 17 million. And I get it with a lot more frequency, the requests. Oftentimes where you see this are people who we talked about before after going through a gray divorce where you don't want to get married again, but you've met somebody else, or a widower and who doesn't want to remarry, and yet they're living together and so desirous of a cohabitation agreement. The other, I'd say, most popular area where you see the cohabitation agreements is for younger couples who are choosing to buy a house together, or if they're moving into one person's home, and so to prescribe their rights in the event of a breakup, as they're not ready to get married yet, but still may have property together. The main purpose that people choose to enter into these types of agreements is one, for the wealthier party to limit their exposure. So it's not like how you discussed, Jonathan, where you have, you're living in Montana and then you may have to pay financial support for somebody that you didn't realize you could have been deemed having a common law marriage with. On the other side, it also can be protective for the less moneyed partner in the relationship. Because in most other states, you're strangers in the eyes of the law if you choose not to get married. And so you could be together for a long time, 20, 30 years, never married. And if there's a breakup, absent the cohabitation agreement, you can be left empty-handed. So it can provide protection both for the wealthier party and for the less wealthy party as well. In addition, sometimes if in a long-term relationship, people just want to prescribe their rights and have an agreement set that forth clearly. So what could be covered under the cohabitation agreements could be as narrow or broad as people choose. Sometimes people just wanted to target one area, which is typically if they're buying a house together. They want to make clear what happens to their down payment in the event of a breakup, what happens to the equity appreciation on the home they're buying together, who's responsible to pay for the expenses during the relationship for their home, and as well as if there is a breakup, who gets to stay in the house, who has to move out, and who gets to stay there and buy the other person out. So that's best addressed in a cohabitation agreement. You also do see where sometimes a couple is moving into a house owned by one person. And so just also to spell out and make it clear in terms of a move out or any sort of expense sharing relationship during the longevity of when they are together. And then it doesn't have to just be limited to the house itself, but you can address topics such as property division in the event of a breakup, financial support from one to the other, as well as inheritance rights. And so that's important to take a look at and to make sure that it's carefully put together to meet both parties' needs. In addition, it's important to consult somebody like Bob. There's unique tax considerations that can come up in these areas because there could be a large transfer of wealth from one to the other provided under cohabitation agreement. So it's very important to take into account the tax consequences.
So before we go on to the next topic, let me just comment again how dramatically the issue of status may change and have to be rethought for many non-married clients if these deemed realization events that are being proposed by Van Hollen, Pascarell, and President Biden get enacted. There is an exception, and again, this stuff is also vague and new and hasn't been enacted, so we don't really know, but there appears to be an exception that if you make a transfer on death to a U.S. citizen spouse under the Von Hollen proposal, there is no deemed realization event. However, for a non-married couple, if they have appreciated assets, the house, right? If they own a house in the Hamptons, it could be a huge number. If we have a deemed realization event and you're not protected by a marital deduction, we may see some wealthy couples have to get married to avoid what could be a potentially 40% income tax on the death of the first partner. So that could change this whole dynamic, and I haven't really seen that addressed at all. So let's go on to our next topic, parenting and children for the single client. I wasn't sure, Jonathan, do you want to start this off and then see if Rebecca has comments?
Absolutely, Marty. As you'll see, this is a quote: among women under 30, more than half of all births are outside of marriage. Think about that. More than half of those births, the mother is unmarried if she's under the age of 30. And if a woman does not have at least a bachelor's degree, she's going to much more likely have, typically is going to be unmarried when she gives birth. In fact, 74% of those people, these are women who don't have at least a bachelor's degree, have at least one child. 74% have one child without a husband. Now, it may be that they live together and then they're just like every other couple that you know that has children, but to think that 3/4 of the women in the United States without a bachelor's degree are going to wind up with at least one child out of, that's going to be born out of marriage. Now, there's laws like the Uniform Parentage Act, which presumes that if the child, that the father, if they're married, that the husband is the father. In fact, there was a case in California where the husband was able to prove absolutely through blood tests, this is before DNA, that he couldn't be the father. But the court said, no, you are the father and you are responsible for this child, even though it was not biologically his child. And, there are certain things you can do. There is something called de facto parenthood, which is very, very similar. There can be forced parenthood. And now we even have, what about children in utero, in other words, in ventre sa mère, where a child is inside the mother, the father dies, they're not married. Is he considered the father when the child is born after him? It wouldn't be a problem if he was married to the mother, but he's not. All of these are important things, and they need to be brought up with your clients. These are difficult areas. Do you have any children outside of marriage? And typically people are embarrassed about that if they're not in a current relationship where they're holding the child out as their own. So these are issues that really need to be addressed, and it's especially likely to happen if you're dealing with a single person.
Rebecca, do you want to add any thoughts or comments?
Sure. So as Jonathan mentioned, it's important to really bring up these topics to see the scope of what you're dealing with and also to help with your planning purposes. So with respect to child-related issues for married versus non-married parents, you have the same issues that exist in terms of custody and child support. And so it's very important as well for for estate planners and other people in other practice areas who are working on planning to ask your clients, is there a custody agreement? Is there an access agreement? Is there a child support agreement that's out there? Because it may have different obligations that fall upon the parent that they have to live up to. So for example, sometimes unmarried parents choose to enter into the agreement after the birth of the child. Other times I see it arise where when there's a breakup, it's very individual what people choose to do in these areas. And so in terms of custody, for example, it can make provisions as to what happens to the child upon death, whether to leave to the other parent, and then they may agree, after one parent dies, who they will leave who they both agree if something happens to both of them. And so it's important that their requests be met. In terms of child support, you can have an agreement that spells out the parameters. So that could include typically a monthly amount of child support payments. And then there's also add-on expenses such as education, health, extracurricular, childcare expenses, and those would be spelled out as well. In addition, in New York and other states, child support's payable till 21. Other states, it's to 18. And so in order to secure those obligations, what you find in most child support agreements is a requirement to maintain life insurance to secure those rights and obligations. And then what you also see in other agreements is a mandate that a parent has to leave a certain percentage of their estate to the child. And so it's important that that matches up for estate planning purposes as well.
Thank you, Rebecca.
Marty, can I ask, can we
Sure.
go back to that prior slide, please? I just want to make sure I understand bullet point G. So if mom and dad are not married and dad dies a week after the baby's born, there's a clear relationship that he's the father. Is that fair? That can be easily proven, or does it have to be?
Well, it depends, Bob. I had the first case of a posthumously conceived child. A man had cancer. They froze his sperm. He died, and later his widow used his frozen sperm to have two beautiful little boys. Other members of the family who saw their rights being diminished opposed that vigorously. There was a case in New York where a guy had gotten a girl pregnant. They were planning to get married, and he died, and she then had the baby. And the question was, could the child inherit from the father's parents? And the court basically said no. Now, the way you establish fatherhood in most states is you either openly and notoriously hold the child out as your own, but that means the child is alive and you are alive, or you sign an agreement that you are the father and you wind up paying child support for that. This is assuming you don't get married. If you get married, the child is, quote, legitimized, although that's kind of an old concept. But if the father dies before the child is born, you probably can prove it by DNA, but virtually no state now uses DNA to prove fatherhood. I think that that's a mistake. And in fact, in the case I had in New York called In Re Martin B, the surrogate was very critical that the state had not come up with, using the best science it could, which is DNA. But you could prove absolutely that if you have some DNA from the now deceased father and DNA from the child, you could prove absolutely that he, in fact, is the father. So if you're dealing with a couple and they're expecting a child, and we want to make absolutely sure that that child is going to get the rights as though the parents have been married, you better have an agreement, or perhaps they really should get married. I mean, this puts the child in a very, very difficult position, especially, again, in inheriting through the father, whether he survives for a little while, but certainly if he dies before the child is born.
So let's just say you have two single people. The father acknowledges that the baby, to the best of his knowledge, is his baby. The lady agrees with him that it could only be his baby, but he's dying. So what do we do before he dies?
Well, if he survives, presumably the child would inherit. In fact, there are cases now where that has happened, and the child was able to get Social Security through the now deceased father, even though they were not married. The problem is where he dies before.
Right.
Again, the law changes, but it changes very, very slowly because, the statistics that 3/4 of women who don't have a bachelor's degree, who have children, that 75% of them will have a child without the husband. I mean, they may be open and notorious about their relationship. They go to everybody's house for Christmas or Hanukkah, whatever it is. But you know, when you and I were growing up, Bob, and I realize you're somewhat younger than me, having to get married was a bad thing. I now say to people that they have to get married, they don't even know what that phrase means. It just doesn't carry the stigma that it used to. So now the child is in a position where it's uncertain what rights that he or she has. So that's.
Thank you, Jonathan.
Let's go on to our next topic, which is estate planning. And estate planning for singles is, again, very different than for married couples. And again, too often the examples and case studies that we see at conferences focus on the Cleaver family, which I think an intact Cleaver family is comprises only about 20% of the family units in our country. So it's far more the exception than not. Jonathan, you want to start us off with some of the differences for single people versus married couples?
Yeah, and it's not just taxes. We all know that if you're married, you get to use the marital deduction. If your spouse is a U.S. citizen, and you get a kind of a quasi marital deduction at death by using a so-called QDOT, qualified domestic trust. And also, you know, you can file a joint return. You can make tax-free transfers during lifetime if your spouse is a U.S. citizen. All of that is very, very good. And sometimes the couple will be better off when they can file a joint return. Although if the husband and wife, or I shouldn't say the husband and wife because they're not married, if the two people basically have about the same income, they are probably going to pay more in federal income tax than if they were in fact single and filing separate returns. But it's not just taxes. There are other rules as well. For example, if you have a spouse who hasn't had adequate quarters of Social Security payments, she or he is still entitled to Medicare at age 65, even though they're not covered. And that happened, for example, for me. We had a disabled child born to us, and my wife could no longer work, and she is a couple of quarters short of having her own Social Security. But when Betsy turned 65, she's 6 months younger than I am, she was able to get Social Security, not from her own Social Security payments or FICA tax payment, but from mine. But if we just lived together, she wouldn't get that benefit. So that's very, very important. On the other hand, being married can be a detriment. For example, if I need to go on some sort of government, you know, welfare because I want to get Medicaid, for example, not Medicare, but Medicaid because I'm disabled or something, and they test me for income and they test me for resources, which could deny me. It's not just my income and my resources they look at, they also look at my spouse's. Yet if Betsy and I were not married, they wouldn't look at hers. In fact, I'm aware of a couple of cases where people have actually gotten divorced so they don't have to have this community income and community resources, which could result in a denial of governmental benefits. This is a complicated area, and if you're representing someone who is in a relationship with another person, and it's not a matter of scolding, saying it's the right thing to do because of religious or other reasons. You just need to explain that there are advantages and disadvantages of being married and also being single. Moreover, and this is probably the biggest one, when someone dies, their spouse, except in the case of state of Georgia, they're going to be entitled to a minimum share of the estate. Now, it varies tremendously around the country. We now have essentially somewhere between 8 and 11 states that have some form of community property. You know, basically that's everywhere from, you know, Louisiana, Texas, New Mexico, Arizona, Nevada, Washington State, Idaho, and Bob, your state, Wisconsin. Alaska has an opt-in system. Some other states have tried to do it, although I'm not sure they've been successful in that. But in the other states like New York, for example, and Florida and Ohio and Mississippi and Missouri, all the states provide the surviving spouse with a minimum share of the estate of the first spouse to die. It varies on what you get. In some states like New York, it's usually a flat 1/3. But in other states, there's kind of an earn-in system. That, I believe, is the rule in New Jersey. The longer you live, the more of your deceased spouse's estate you'll get. But if you're not married, you get zero. And that may mean that, you need to, if you want your spouse to be assured of getting something, you better have a contract to that effect.
That goes back to the living together agreement that Rebecca spoke about a little while ago. Jonathan, why don't you continue, and then I'll talk in a few minutes about some of the planning.
Yeah, I'll just mention from a tax perspective, there can be great advantages. If you live in a community property state, when the first spouse dies, not just does his or her share of the assets get an income tax-free step-up in basis, but the survivor's half of community property also gets that step-up in basis. That double step-up in basis is exceptionally important. I mean, it's just a great thing. And in fact, Bob, I'm sure that the married people in Wisconsin just love it that the legislature adopted the Uniform Marital Property Act, which the IRS in Revenue Ruling 87-13, you can look it up, 87-13 says that we will treat the marital property under the Uniform Marital Property Act in Wisconsin as though it's community property. So the couple gets this double step up in basis when they die. You don't get that just by living together. Although, again, you might contend, no, we have a common law marriage and we live in Texas. So we do get that double step up in basis. By the way, everybody in a community property state takes the position when the first spouse dies that it was all community property, so they get it. Even if each of them brought separate property to the marriage, which didn't become community property, in preparing the estate tax return because of the unlimited marital deduction, there's no downside. They'll say, no, it was all community property, so they get that double step up in basis. Much of the income tax law favors married couples, but there are some detriments. For example, the $10,000 limit on the state and local tax deduction, it's per person unless you're a married couple, and then it's just one for those two people. If they file separately, they only get $5,000. So the tax law kind of discourages marriage in that case, which is, it's very, very silly. But marriage is an important thing in our world. Marty, why don't you tell us something about estate planning and how it might apply to single people?
So just given time, what I'm going to do is kind of jump ahead just a little bit and talk about some of the estate planning that could be done. So one of the default common plans that's used for married couples is the spousal lifetime access trust. Husband sets up trust for wife or spouse one for spouse two, and spouse two sets one up for spouse one. You build in various differences into the trust so that you can negate hopefully a reciprocal trust challenge by a creditor or by the IRS. And the concept behind slats, and then we'll bring it home to single individuals, is that if I set up a trust for my wife, she's a beneficiary of my trust. So long as we're still married and she's alive, I can indirectly benefit out of the trust I set up. She sets up a trust for me, and ditto, so long as I'm alive and we're married, she can benefit from my being a beneficiary of the trust she created. So if we put $100 in each trust, theoretically, we can both benefit either directly or indirectly from this $200 that we've transferred out of our estate. What do you do for a single individual? And part of the problem is simply the naming convention that's been used for these trusts. The SLAT, the acronym Spousal Lifetime Access Trust, doesn't have to only be for spouses. You could set up, with the current $11.7 million exemption, two non-married individuals could set up a trust for each other and whoever else they wanted. So if I'm not married, I could set up a trust for my partner and then name nieces, nephews, or charities, or whoever I want as remainder beneficiaries on her death. So the acronym is part of the problem because it's not confined to spouses. You can set up somebody, I think it was Teresa Bush from Interactive Legal, dubbed it the RELAT, Relative Lifetime Access Trust. So you could do it for brothers, sisters, siblings, partners. So the same concepts can be applied. You just don't have a marital savings clause in the provision, but it can be done in a very similar way. So what we need to do is rethink, especially in the current environment, for those single clients that want to use exemption, what do we do? Now, for a single client that doesn't want to, doesn't have a partner and doesn't have children, is there any rationale at all for doing any kind of trust? Well, there very well may be. if a single individual with no children, if they die, wants to leave their wealth to their siblings or their nieces and nephews, to anyone, getting those assets out of their estate today using exemption, obviously subject to the potential deemed realization if Von Holland is enacted retroactively, is good planning. And too often our single clients, if they feel they don't have children that they're trying to save estate tax for, don't focus on estate tax planning. And right now in this environment, if there's a risk, which many perceive there is, that the exemptions will be reduced significantly, they should in fact be doing planning, and they should in fact move assets out of their estate, even if it's to benefit another family member. But there's another reason that's very important as well. And this may also be reflected in the type of trust that's created. But let's say you have a single client, a physician, and she's worried about malpractice claims. She has no plans on marrying, no plans on having children. She still wants to protect her wealth for herself from malpractice claims. So setting up a trust, whether it's a relat, a slat, but for a relative like a sibling, or a self-settled domestic asset protection trust, a DAPT, or a hybrid DAPT, which is a trust for perhaps, let's say, nieces or nephews, but she can be added back as a beneficiary, or a SPAT, a special power of appointment trust, where let's say it's a trust she creates for nieces or nephews or cousins or whoever she wants to benefit, and gives somebody the power to direct distributions of special or limited power of appointment to her. Those mechanisms still work. Now, unfortunately, some colleagues of ours feel that DAPs are quite risky, and there's been talk, especially if you live in a non-DAP jurisdiction, of the risk with DAPs. And that's a little disheartening, excuse me, because a married couple can set up slats in those jurisdictions, and most advisors would suggest that that should work, and there's little risk associated if it's properly drafted and administered. But why should a single client not be able to get a comparable benefit by doing a DAPT? But because of that risk, which can't be quantified, using a SPAT or a hybrid DAPT may be viable options that we should be able to consider in doing the planning for the single client. Now, let's see what else.
Well, Marty,
so,
just let me mention that there is positive and there is negatives in having a spouse. For example, if you are dealing with a foundation or a charitable lead trust or a charitable remainder trust, which is subject potentially to the self-dealing taxes under Section 4941, you're going to be tainted by anything that your spouse does. So if I want to buy something back from a foundation where I'm a disqualified person, I can't do that. I'm going to be taxed to death. And the same thing would be true if my spouse does it. But if I'm just living with that person and we haven't formed a common law marriage, she or he could go ahead and buy that asset back, and there would be no self-dealing, even though we have as strong as relationship with each other as a married couple does. So there's good news and there's bad news with respect to that. One of the bad things about being married and doing a trust for your spouse is that because Section 682 was repealed in the 2017 Tax Act, now if you and your spouse get divorced, that trust is going to continue to be a grantor trust with respect to you. Keep in mind, and this is another statistic, and I think, Rebecca, you'll love this, the New York Times did a special survey a few years ago, and one of the questions they asked was, do you know someone whom you're positive is going to go to hell when they die? 20% of the people said yes, unless they'd been divorced, and then it was 65%. So typically, you're not going to have warm, rosy feelings about your ex-spouse. And can you imagine, you've created this trust for your ex-spouse. You're now divorced. It's still a trust for your ex-spouse, but you continue to be taxed on the income. Wow. Well, that's something that you need to take into account in preparing that trust, saying basically, if we get divorced, my then ex-spouse is out, or she or he can only receive distributions with the consent of an adverse party to prevent it from being a grantor trust with respect to you. You don't have to worry about that if you haven't been married. So you could create a trust for your significant other. and your significant other could create a trust for you, and you wouldn't have to worry about Section 682 and continuing to be taxed on the income, provided you didn't make it a grantor trust from inception.
Let me add a couple of comments on slide 27, and then we'll go on to what I think is our last topic. So long-term care insurance, what relevance does this have to planning for a SLAT, DAFT, or other type of irrevocable trust? We've already established that for many single clients, it makes a world of sense to use exemptions so that they can protect assets from potentially greater estate tax when they leave them to different heirs, or even if it's not a concern of theirs about heirs that may be going to charity, to protect assets for the rest of their life from malpractice or other claims or suits. If a client is making a large transfer to an irrevocable trust, I always encourage the client to meet with their financial planner and their insurance consultant and have a review done. You know, if it's a married couple, I would look at, you know, using life insurance in context we've talked about in SLAT presentations. What about the single individual? Well, if the single individual is still working, you should really make sure they have adequate disability income replacement coverage. So if the single individual is transferring millions of dollars to a trust to use up exemption, and they are incapacitated next year, we need to make sure they have adequate resources outside of the trust. Even if it's a self-settled trust, you don't want to access it immediately, and you may have restrictions on when it can be accessed. But a common restriction in a self-settled trust is that it can't be accessed by the settlor for 10 years and a day, so it takes it outside of the Bankruptcy Protection Act. But if that's done, what happens if the individual is disabled and can't work? So disability insurance is critical. If they're making a large transfer to a trust, having long-term care coverage to replace the wealth that's transferred to take care of medical needs could be critical. And with the single individual, all these things these insurance coverages are even more important because they don't necessarily have a spouse or partner to rely on to provide care. So the insurance coverage, especially long-term care, is very important. The last point on slide 27, you know, where somebody has that Cleaver family situation, there's anticipation that the money goes to the spouse in trust, and then on the spouse's death to the kids. And there's what we call a natural order of distribution. With a single individual, especially one without children, you know, there could be a whole wide range of dispositive schemes. It's not uncommon to see a single individual leave money to certain nieces and nephews that they were close with, but not to others. So all those types of bequests increase the potential likelihood of a will challenge later. Now, if you're doing an irrevocable trust and it has the same dispositive structure as the will, that sort of reinforces the plan the individual wants, and getting assets into an irrevocable trust helps protect them for the dispositive scheme the single client wants. Certainly some consideration could be given to premortem probate to deflect those kind of challenges by having the will admitted while the client's alive, if the client's comfortable doing so. And there's a number of states, I think New York and Alaska are two, I believe Delaware as well, permit premortem probate of even non-residence wills. And therefore, it gives you a mechanism for a client with, let's call it an unusual or non-consistent dispositive scheme, to secure that before there is a potential contest.
Now, Marty, New York does not have premortem probate. Alaska has it, and it even permits non-Alaskans to use it. And I've had a number of people use it in Alaska. North Dakota has it, Ohio has it, but the vast majority of states don't. And I'm going to be a little unkind to some of my brethren by saying many probate litigators hate the concept of premortem probate because it doesn't mean there'll be a battle once the person dies, and that means they won't get the big fees for bringing on or defending a will contest. So if you anticipate that the family of your client who's single is going to object if the estate or significant portion of it is left to the person with whom they live, maybe it's a homosexual relationship, to women, to men, whatever, or if it's just that they're living together, but that you think the parents or the brothers and sisters don't like it, and they're going to object because it was left to the significant other, you really need to consider premortem probate, or at a minimum, have an irrevocable trust you can create an irrevocable trust without making it a completed gift by retaining certain powers of control, but do something, because there's a very good chance outside of a traditional marriage, when something is left to that significant others, that the other family members are going to come in and object to that disposition and try to get it for themselves.
Let's quickly go through our final topic. So one of the largest cohorts of singles, and a growing cohort, is older single clients. And as we gave you some statistics earlier, many of these individuals are single by choice and have always been single. As we start to reach into the much later years, 85 and older, many of these individuals are single as a result of the death of their spouse. And we have this growing incidence of silver divorce. And it says in the second item on page 29 that the number of Americans over 50 that are getting divorced has doubled in recent years. So it's become a significant trend. And the bottom line is we are seeing more and more very elderly single individuals. And what is the unique aspect of planning for them? Well, first of all, the incidence of chronic illness grows with age, and the number of individuals over age 85 that have some degree of cognitive impairment or chronic disease or multiple chronic diseases is very, very substantial. And as they get older, those risks will grow. So what do we do to help these clients? First of all, one of the issues we have to address for them is the risk of elder financial abuse, which is a burgeoning epidemic. It's a very, very difficult situation. And the way to help protect those clients is using many of the tools that we're all familiar with. First, I like to see a funded revocable trust, so that you have assets in a trust, which to me then gives you the ability to name an institutional trustee or co-trustee, because many of these single individuals don't have family members. And as they get on in years and elderly, many of even their close friends have either passed or no longer have the wherewithal to serve in those fiduciary capacities. So once assets are in a revocable trust, you can readily name an institution as a co-trustee or sole trustee after perhaps the client, or you can name a combination of an individual family member trustee, friend trustee, along with the institution. And the institution will provide some objective safeguards that could be invaluable for the aging single client. So that's something to give some thought to. And one of the things that we have to do, the second bullet point on slide 30, is many of our clients will name, family members, spouse, then children. Single client that's never married, has no children, doesn't have the usual cast of characters to name in these fiduciary positions. And I've sometimes seen people reach to neighbors and people that they call friends, but to whom their relationship is really very tenuous. And they may very well be much better off with the independence and objectivity and safeguards that an institution can afford to them. So I think we need to engage these clients in these discussions and have a much more in-depth, detailed discussion of who can serve in these various capacities, how they can serve, and what we can do to help add a safety net for them. And if you create a funded revocable trust, I'm seeing more use of trust protectors, even in revocable trust, not just irrevocable trust. But I think for the older single client, it's a critical step to take to provide some of the checks and balances. So if you have an institutional trustee, an individual trustee, and a trust protector, if the client starts to develop cognitive or other challenges as they get on in years, there's now 3 different persons, including an institution, functioning in fiduciary capacities to keep an eye on them. And that can be complemented by really making sure you cobble together a team of advisors, an independent accountant, financial advisor, wealth advisor, trust company, insurance consultant, estate planning attorney. If you have an advisory team of 3 or 4 people, and the 3 people that I mentioned on the revocable trust, you have a fairly meaningful set of safeguards to watch out for the client as they age and have issues. What I'd like to do, because we're kind of near the end of our time, I'd like to ask each of the speakers to make any sort of summary comments or recommendations on our topic. Rebecca, why don't we start with you?
So I think that it's just important to keep in mind that the more cohesive your planning is, the better. So to make sure to have your clients all have their advisors speak to each other, from your estate planner, your family lawyer, your CPA. It's all very important so you can come up with a cohesive plan. Also, to keep in mind a cohabitation agreement for your clients. They can go a long way in protecting individuals and preserving their wealth, and in terms of easing any sort of breakup, as well as in for older couples, and when they find themselves in these predicaments after a great divorce, that there are often uncharted territory that people aren't expecting. Their wealth is oftentimes cut in half, and so it becomes extra important to preserve their nest egg, which they may need the remainder of their life. And thank you, Marty, for organizing the program.
Bob, do you want to make some final comments if you're still on? I think we may have.
I'm here.
Oh, okay.
But I think the important thing here is so you consciously recognize how much different planning for single people is. Take to heart some of what Jonathan shared about determining paternity when the dad dies, why the mom is pregnant. Does that happen a lot? No, because we're normally dealing with younger people, but it's probably happened once or twice in everyone's practice. So you want to make sure that that baby is not somehow financially, they're hurt financially because it's just the way the law might operate. And so that's important. Remember, all these carry forwards, we can use them in some way. Remember, if a couple gets divorced, check all those beneficiary forms, every single one of them. Get them back to an estate planning lawyer who can look at their whole estate plan holistically and make sure everything's in place. Marty?
Jonathan, you want to make any sort of concluding comments?
Well, I think the most important thing to say is that if you have a client who's single and doesn't have a descendant, getting them to do any planning is going to be really challenging. And the thing that I have found to kind of spur them is to talk about how it can benefit them. For example, a revocable trust is a nice way to avoid probate, but really the revocable trust is for the property owner. So if he or she needs financial help, it's there. And if you have to go and get a guardian appointed, it's going to be a mess. So talk to them about, this is for your own protection. If they have kids, obviously they're much more prone to do it. But a lot of people I know who've never married, even if they live with a significant other and they don't have kids, just neglect their estate planning, and it shouldn't be that way. So one of your jobs is kind of to spur them into taking action. And again, you're going to have to try to tickle their selfish bone to get them to do something like a revocable trust, or even designating a medical attorney in fact. I mean, what are you going to do? And think about this. If you're living with someone else and you go to the hospital, I mean, I know they're going to let my wife in, but if it's my girlfriend, even if it's a live-in, the hospital might say, no, you're not a relative. You can't come in, and you have no say over matters. So make sure they do a healthcare proxy, a living will, a power of attorney, including a medical power of attorney, and a revocable trust. Very, very important, as well as Bob was talking about. Make sure that the beneficiary designations on life insurance policies, on pension plans, and anything else that won't be passed under a will gets proper attention. Marty, back to you.
So just to conclude, let me just echo and expand very quickly on a couple of comments made by Jonathan and Bob. You've got to be very mindful that you can't take your Cleaver family template of many of the planning ideas, strategies, techniques, documents that we use routinely for married couples and graft them onto a single individual. Things are very different, and we need to be aware of that. And we need as a profession to talk more about this topic, because the statistics we gave you in the beginning make it eminently clear that there's a huge proportion of our population that is single, and we need to help them. I think Jonathan's comment is, and I'm going to say unfortunately true, because when people are not feeling motivated to plan, it's very hard for us to help them. And there's an awful lot we can do. I mean, some of the comments Rebecca made about investments. If somebody is single because their spouse died or is divorced, their whole financial picture may have changed. They need to sit down with their wealth advisor and reevaluate their asset allocation. You know, maybe they need to take on more risk, less risk. Maybe they need different insurance coverages. You got to review all that. Getting somebody motivated, I think if you focus on asset protection to protect them, a funded revocable trust with the safeguards that we talked about to protect them through disability, reassessing long-term care coverage, because who's going to come into your house and help take care of you if you become ill? And the statistics on that are pretty concerning. So I think if we can reframe the conversation to not saving taxes for your children, which is often not applicable, to how we can help protect you, I think we can help motivate these clients. And again, as with so many planning ideas, it's really a team affair. So, Rebecca can't necessarily get somebody to come in and do a living together agreement if one of the other people on the advisory team doesn't recommend it. And if somebody has just gone through a difficult divorce, especially at an older age where it may be more traumatic emotionally to them, how are we going to get them to their wealth advisor? It's critical that they reevaluate their insurance and their investment planning. So I think whichever advisor the client happens to speak to, we should all carry the same message to encourage and guide and educate the client to understand how and why all the other advisors can help them with the topics we've talked about. So I want to thank everybody for joining us. I want to thank our panel, especially Bob and Rebecca, who I arm twisted to join at the last minute, but I thought they added some great insight, and I think it really rounded out the topic. And good luck to all of you with planning for your single clients. Thank you for joining us.
Thanks, everyone.